I was not persuaded to accept the defendants' AFL submission that a finding could be made on this particular issue following contained discovery, limited by issues of relevance, materiality and proportionality. That the AFL was, or was not, acting to protect its commercial interest is relevant to defining the scope of discovery, Justice Dixon said in his judgment. In his statement of claim, Taylor alleges several statements by McLachlan about the AFL's joint investigation with the Australian Sports Anti-Doping Authority, ASADA, were misleading or deceptive. Taylor has pointed to comments made by McLachlan on Fox Footy's AFL 360 and radio stations 3AW and 2GP, and comments made in the Herald Sun and The Age as reasons why he should be questioned. I accept, as the plaintiff submitted, that the court must determine whether the statements were made in an attempt by the AFL to protect its commercial operations. Justice Dixon wrote, the AFL's business, in large part, depends upon the way it is viewed by the public, because its income is derived from television revenues, membership and ticket sales, controlling the clubs and the competition so that the public have faith in the integrity of the competition may be a necessary part of that activity. Justice Dixon said a third matter relating to deed of release would have to be debated at a separate hearing. In an important financial win for Taylor, Justice Dixon ruled that the AFL had to pay his expenses. Gillan McLachlan, left, and Mike Fitzpatrick. Photo, Pat Scully. Taylor has also alleged several statements made by AFL executives about former Essendon coach James Hird, player welfare, an interim report by ASADA and the AFL's decision-making, are examples of misleading or deceptive conduct. This includes McLachlan's denials that he had asked ASADA to take bits out of an interim report that had not been favorable to the AFL. One claim is that McLachlan attempted to reach an outcome before players and Essendon officials had been interviewed by ASADA and the AFL. Taylor has also taken aim at Fitzpatrick over claims he said Hird would never be allowed back into football. There is an appearance that the presence of Mr. McLachlan and Mr. Fitzpatrick is gratuitous despite being probable witnesses for the AFL, Justice Dixon wrote. The plaintiff submitted Mr. McLachlan and Mr. Fitzpatrick's presence in the litigation, and the proper resolution of those questions depends on what the evidence ultimately reveals about the reasons they engaged in the conduct in circumstances where it was important to understand the AFL's intention in making those statements through its two senior executives. The plaintiff says that these factual questions can only be explored properly after discovery and on the basis of evidence from witnesses at trial. Taylor has worked with law firm Arnold Block Leibler in Melbourne and was a partner at Latham & Watkins in London. He has no direct links to Essendon, but told the Supreme Court in June last year that the proceeding was a once-in-a-lifetime case. John Pierik is a sports writer with The Age, focusing primarily on AFL football, cricket and basketball. He has won awards for his cricket and basketball writing.